How's it going, everybody? In this video, I want to talk about the impact that the New York State Rifle and Pistol Association v. Bruen case will have on California gun cases. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to uphold our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is Safe Life Defense. Safe Life Defense has some of my favorite soft body armor out on the market. I actually like to keep one of their soft body armors in my car just in case. So if you guys are interested, head on over to Safe Life Defense. Right now, they're probably still running a Cyber Monday Black Friday deal. And if you use the code ARMSCHOLAR, you can get an additional 10% off of your order. Also, I want you to know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, in this video, I want to go over something that a lot of people have been asking me, and that is what impact the New York State Rifle and Pistol Association v. Bruen Supreme Court case will have on important California gun cases like those in the state of California, the California assault weapons ban case, the magazine ban case, and other challenges as well, like challenges to the California handgun roster. Now, for those of you who are not aware of what's going on in the New York State Rifle and Pistol Association case, or you don't understand why it's so important, let me explain real quick what's going on. The New York State Rifle and Pistol Association case is a challenge to the state of New York's concealed carry permit requirements. The state of New York requires a person to provide proper cause to be issued a permit to carry concealed. The issue is that the state does not consider self-defense a proper cause, and therefore on that justification alone, people have their permits denied. Essentially, a person has to distinguish themselves from the average person to be granted a permit to carry. So the whole question in this case is whether the state of New York violated the Second Amendment with their whole May issue licensing scheme that does not treat self-defense as a sufficient justification for a permit to be granted. Now, the Supreme Court heard oral arguments in this case, which is very important because it is the first Second Amendment case the Supreme Court has heard and will rule on in a very long time. But essentially what happened is after those hearings, many of my followers in California have been asking how the New York State Rifle and Pistol Association case will impact California gun cases like the ban on so-called assault weapons, the magazine ban case, and other types of cases as well, and maybe what impact it will have on concealed carry in California. Well, the main impact the New York State Rifle and Pistol Association case will have on cases in California will likely be dependent on the Supreme Court affirming that text, history, and tradition is the legal analysis that must be used in all Second Amendment cases. All of the parties and many of the justices during the oral arguments appeared to acknowledge that text, as informed by history and tradition, is the correct analysis when dealing with Second Amendment issues. So for example, in response to a question from Justice Gorsuch on what is the proper type of analysis, the state of New York's representative actually said, "I think our view is that courts ought to follow what we understand to be the lesson from Heller, which is that you start with the text, history, and tradition, and when those sources provide you an answer one way or the other, either that the law is valid or that it's invalid, you end there and that's the end of the inquiry." Now, this is a drastic change in perspective that states like California and circuit courts like the Ninth Circuit, which control the state of California, have refused to use. The state of California has argued in all of their cases that balancing of interests is what the courts should use as their test, not text, history, and tradition. Currently, the Ninth Circuit has established what is known as the two-step approach as their analysis when they review Second Amendment cases. In this type of analysis, the court first asks if the challenged law affects conduct that is protected by the Second Amendment, and if it does, then the court moves to step 2 to determine what level of scrutiny will apply. Well, during the oral arguments, you had Justice Gorsuch ask a few times what they should do about lower courts like the Ninth Circuit, who have used tier-based analysis in the past instead of text, history, and tradition. In response, the petitioner's attorney stated during the oral arguments that I think if it wanted, it could go a long way to correcting some of the mistakes in the lower courts to say that text, history, and tradition is the test, not part of the test, but the test inside and outside the home. Now, like I mentioned during the live stream, if you watch along with me, I think when hearing these lines of questioning, a lot of the lower courts like the Ninth Circuit and the state of California pretty much said, oh crap, because the state of California's gun control laws have been often upheld or almost always upheld through a balancing of interest test. Well, now you have it being keyed up that in this ruling, there could be language reaffirming that text, history, and tradition is the entire analysis, and that it's the analysis start to finish. and that the Ninth Circuit's use of the two-step approach this whole time has been clearly wrong. This would open the floodgates to re-litigation of many of the California gun cases, and it would also unravel many of the Ninth Circuit's anti-Second Amendment decisions that they've issued in the past. Gun control laws like California's handgun roster have been upheld using a balancing of interest test. Well, that was clearly incorrect, and this decision will lead to that issue being relitigated using the correct type of analysis. The Ninth Circuit's ruling in Young and Pena, which found that the Second Amendment does not protect your right to carry a firearm outside the home whatsoever for self-defense, can also be re-challenged because the Ninth Circuit again refused to use text, history, and tradition as the entire analysis. Instead, they used the two-step approach. And then for active cases like the Miller assault weapon ban case, the Duncan magazine ban case, the Rupp assault weapons ban case, the Rhodey ammo day case, likely what you will see happen is a 28J letter will be submitted to the Ninth Circuit. That letter will state that the Supreme Court recently issued a ruling in the New York State Rifle and Pistol Association v. Bruen case, and that in that decision, the court stated text, history, and tradition is the entire analysis. The letter will also likely point to other important language in the decision that supports a finding that California's assault weapons ban or their magazine ban or whatever case that is being challenged that would support that that case should be found in favor of gun owners in the state of California because those laws in the state are unconstitutional. So to answer plainly what impact the New York State Rifle and Pistol Association case will have on California gun cases, well, likely it will have a major impact on all of these cases. California in the past has only been able to get their gun control laws upheld in the Ninth Circuit because the Ninth Circuit refused to use the correct type of analysis. Instead, they used the wrong two-step approach. After this decision, the Ninth Circuit and the state of California will no longer be able to do that. They will no longer be able to hide their unconstitutional laws in the courts. Now, does that mean that the state of California won't try to do something else? No, the state of California will try to do anything that they can to keep these gun laws in place. But legally, all these laws should find no more safety in the Ninth Circuit because the Ninth Circuit will no longer be able to use that analysis, which is clearly incorrect. So the future of gun rights in California should be really interesting. And I'm personally excited to see all these cases finally head the correct direction in favor of our Second Amendment rights. And of course, I'm in favor of that because also I'm still in California. So I'm anticipating the change in law just like everybody else in California. And like I said, the New York State Rifle and Pistol Association case can have major impacts on all these cases because it goes at the core of the type of analysis that must be applied in all these Second Amendment issues. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell. You guys are directly impacting these videos, impacting this channel, and helping me to reach more people than I could have ever thought. So thank you so much for all of your support. If you don't have a comment in mind, just comment down below that you're coming to fuel the algorithm. And also if you're a new subscriber or a longtime lurker and you subscribe, go ahead and comment down below that you're a new subscriber and I will make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this is Built by Armed Scholars and Station we maintain by Armed Scholars.